Okay, I see live stream is showing up right now. Okay, good morning.
Morning.
My name is Henry W. Green Jr., and I will be the presiding judge. Before we get started, let me introduce the other judges here. We have G. Gordon Atchison, and we have J.C. J. Hurst. These are other judges on the panel. And before we get started, I'd like for us to let me call the case. The case is 123642 Northeast Comanche Tribe, Inc. And is it Abraham Shalon? Is that how you pronounce that?
It's Shiloh.
Shiloh, okay. And thank you very much. Versus Christina J. Stumpf, Ronald Ward, Malcolm Dickinson, and Peter C. Morse, appellants. Now, I'd like to get the appearances of the parties. Appearing for the appellant, or appellants?
Yes, Your Honor. Mark Wilson of Securitas Financial Law, LLC.
Good morning, Your Honors. Jeff Spahn and Matt Spahn on behalf of the appellees, Northeast Comanche Tribe, and Ab Shiloh.
Okay, for the appellee, who would be arguing? Is it going to be Jeff or Matt?
It's going to be Jeff.
Jeff?
I'm known as the antique Spahn, so.
Okay. Now, this case has been set for 20 minutes, and I guess understand as far as the who are here to argue today, I guess we are unified in interest in the issues that are going to be presented by the appellant and the appellee. Is that correct?
Your Honor, I don't understand what you're asking.
Okay, okay. Because I have so many attorneys listed here for the various parties, I didn't want to make sure that there is not a party that I've already had gotten appearance for may want to argue, but the interest is not unified. And because, look like I'm not going to have any problems with this situation with two of you, where how I split up the 20 minutes, okay? See, if there was more than one party, and if the interests weren't unified, there would be a problem. The parties would have to decide together how much time they're going to get with each other. Yeah, I don't want to confuse that. Okay. The appellant, Mr. Wilson, you have 20 minutes, and do you want any rebuttal time?
Your Honor, I'd like to reserve 5 minutes of my time for rebuttal.
5, okay. And are you ready to proceed with your argument?
I am, Your Honor. Again, Mark.
Before we get started, I'd like for you to tell the audience a little bit about this case, okay? And when you do tell the audience about the case, it won't be used against the time I'm going to allot for you. So if you could take 2 or 3 minutes to tell us about your case and the issues, I would appreciate, and this is for the audience.
Yes, Your Honor. May it please the court. This is a case about a nonprofit board calling an election that complied with law and another member of the board calling his own election. And the reason that we are here today is to interpret the Kansas Free Speech Protection Act, which is KSA 605320, and how it applies to the pleadings in this case. The name of the parties can be a little misleading. This is an organization of pilots of Comanche Piper aircraft, and it has nothing to do with Native American tribes. So this is a nonprofit club, nonprofit association that is gathered together for pilot training purposes and camaraderie and things having to do with the flying and maintenance of Piper Comanche aircraft. Is that a good enough summary of where we're headed with the case, Your Honor?
That is fine, Mr. Wilson. Thank you very much.
Thank you. And I want to start, again, this is about a board of a nonprofit holding an election, and a board member, another board member who participated in and lost the election, decided to call one on his own. And the reason this case,
excuse me, Mr. Wilson, he didn't just call it on his own. The ICS essentially conducted that election. It was under the auspices of the International Comanche Society, wasn't it?
Your Honor, the board of directors of the Comanche tribe, as presented in defendant Stumpf's affidavit, authorized an election of the board, and it was conducting that election of the board when ICS intervened and had an online election that was not authorized by the board. The board sent a letter to ICS.
Excuse me.
Yes, Your Honor.
But to say that Mr. Shiloh just ran out and had his own election isn't really at all accurate. There were two elections, one of which may be invalid, both of which may be invalid, and there are competing slates of putative officers derived from each of those elections, correct?
That is correct, Your Honor.
And each of those, the chief or the head person has been filing stuff with the Secretary of State, and there are dueling filings from each of the slates and other disagreements between the slates as to who runs the Northeast tribe, right?
That is absolutely correct, Your Honor.
Okay, and so, all right, go on.
Yes, and should we reach step 2 of the act analysis, will show that the plaintiffs cannot show that they held a valid election. But that's only, of course, if we reach step 2.
Well, actually, that was going to be one of my questions.
Yes.
Reading the briefs, it seems to me both sides have invited us to consider and resolve step 2, assuming that you were to prevail at step 1.
That's correct, Your Honor.
Reverse the district court. And I assume you think that we have the authority to do that because it presents a legal question.
Yes, Your Honor, and both sides agree that the standard of review is de novo.
Okay.
So yes, we believe you can and should decide both steps.
Okay, and one of the things I was going to ask you, and I'll ask Antique Spawn as well, is assuming we agree with you and we go on to step 2, what's your best argument, or give me your best arguments on step 2 as to why the plaintiffs here have not presented a prima facie case requiring some resolution of this dispute over who the board is?
Right. Well, the Kansas law provides a checklist of items that one must satisfy to hold a valid board election. And here, the plaintiff pleads that there were 4 or 5 holdover directors, but doesn't plead that those directors actually called the election he allegedly won. In reality, and as I mentioned, as set forth in defendant Stumpf's affidavit, Shiloh was participating in an election that was duly called by the board, which he admitted only when this motion to strike got filed. That admission is found in his affidavit filed in the case below. So instead of continuing to participate in the election, he did go off by himself, we allege, and held an election on his own that he knew wasn't authorized by the board and that ICS knew wasn't authorized by the board. So, additionally, he pleads that these 4 or 5 directors, that Article 4 of the alleged bylaws, we don't agree there are, but if there are, he alleged in one case that those remaining directors, Article 4 allows those remaining directors to select members of the board who were resigned, removed, or replaced. But he didn't go that route in the articles, he didn't appoint the board members and then authorize an election. He had the option to file a suit as a member under 6505, alleging that no timely election was held, and then ask the court to hold one. And he also pleads, originally he pled, there are no directors. And if that was the case, he could have gone to 1765-13 to call a meeting of the members or request that the court call a meeting of the members to have an election. So, and in addition to that, he pleads that there was an electronic online meeting of the members. He doesn't plead it was called by the board. And he doesn't plead that the online election was authorized by the board. So
okay, what's the source for his obligation to have the endorsement of the board for that procedure? Is that, where does that come from?
Well, Kansas statutes clearly place the authority to hold elections for the board in the hands of the board. And it has steps to follow in various statutes that are cited in our brief, steps to follow for properly pleading that you have a valid election. And their pleading is woefully deficient on this front. You know, in sum, on this point two, before I move again to point one, they can't show by substantial competent evidence that they held a valid election. The pleading is deficient in those many ways. Back to step one, though. This is basically an application of a statute to a pleading and a motion, and the act applies to just about any lawsuit filed in the state of Kansas. The definition of a claim in 605320 C1 in relevant part defines a claim as any lawsuit or judicial pleading or filing requesting relief. So obviously the act applies to any lawsuit filed in Kansas without exception, including here the First Amendment petition and the verified application. Likewise, the definition of communication in subsection C2 is anything oral or written in any form or medium. So this can be email, it can be alleged statements, representations made to other members in this case. And as with the definition of claim, there are no exceptions for context, type of suit, or any other reason. So really, there are no limitations in the act with regard to claims and communications that meet the statutory definitions of the three exercises of association, petition, and free speech.
Are you saying then that a motion to strike would lie in basically any civil case filed in the state of Kansas?
Absolutely.
Is that your position?
Absolutely. And that is the clear intent of the legislature applying the definitions in the statute. Absolutely.
Why didn't they just say that then? That a motion to strike can be filed in any lawsuit in Kansas? Well,
they did. They said it can be filed against any claim, and they defined the claim as any lawsuit or judicial pleading or filing requesting relief. And, you know, courts in other states, California and Texas, have interpreted this the same way.
Okay. I want to be sure I'm understanding what you're saying. You're saying in any Chapter 60 action, the defendants can file a bona fide motion to strike under this statute.
They can file it only if the claims in the lawsuit relate to the protected privileged communications. And in this case, they do. Those next three definitions of the exercise of association, petition, and free speech are very important here. So yes.
Well, okay.
Yeah, any defendant can file it as long as the conduct complained of fits those definitions.
Okay.
So the moving on to the actual definitions of the conduct, these exercises of, and by the way, Judge, what this statute does, it doesn't call upon the court to decide to decide if somebody's right to free speech has been violated under common understandings of constitutional law. What it does is it reduces these rights to definitions in the statute. And if it meets the definition of these exercises of the rights as defined in the statute, then you can file a slap motion to try to strike the claims. When the conduct complained of in the lawsuit and the relief requested is factually predicated on or arising from the facts pled, then step one is satisfied. Here, regarding association, the tribe itself is, in quoting the definition of the right of association, individuals who join together to collectively express, promote, pursue, or defend common interests. And even the court below so found in its finding of facts. Therefore, when plaintiffs invoke these communications that defendants made to the tribe membership, and especially when they seek to enjoin and put a prior restraint on these communications, it certainly satisfies the exercise of the right of association, and therefore it satisfies step one.
Are you referring to the request for the injunctive relief?
I am referring to all three counts. And, you know, in count three, and we have yet to discuss the right to petition, but count three, all it is damage, asking for damages for making filings in court and with the government. And in other states, filings, ordinary filings like gosh, I had my notes here, a title filing there's a California case that says a filing about the title of a piece of property was actually a privileged communication because it was a government filing and they had a right to make it.
Well, I understand, and the constitutional right to petition includes the right to file lawsuits. But
yes.
As I read the third claim, I mean, I think it's the third one, it's the one we're referring to here. The issue was whether dues paid to the Northeast tribe were properly expended by the one board of directors in this lawsuit in Michigan, challenging basically the plaintiffs in this case, plus the internet or the international in setting up the election.
Yes.
Okay. So it's not precluding the lawsuit, it's questioning whether that was a proper expenditure of the members' dues.
Right, and that analysis
relief for that, right? I mean,
yes, that satisfies step one. And
how?
Step one, it does not call upon the court to analyze whether the suit was justified. The suit could be completely unjustified, but the complained of conduct in this case is filing a lawsuit. And filing a lawsuit is protected communication.
Well, that isn't, though. I mean, the complaint of conduct was the wrongful, quote unquote, expenditure of the dues, and that may or may not be the case. It's not the lawsuit. If your clients had paid for the lawsuit out of their own pocket, count three wouldn't be in there, right? Presumably. So it's not it's not saying you can't file the lawsuit. It was who paid for it.
The definitions do not, respectfully, the definitions do not call upon the court to make that analysis. They simply ask the court to apply the statute and say if the claim arises out of this protected conduct, then the conduct is subject to the act. And the exercise of the right of petition includes a communication in or pertaining to a judicial proceeding. That's right. All. Right. If they complain that somebody filed a lawsuit and they're asking for relief because somebody filed a lawsuit, then that satisfies step one of the act by itself.
But that's not the complaint.
The complaint arises out of. Yeah, it arises out of this conduct. And again, that's not to satisfy step one, whether or not that suit was authorized, whether or not it seeks to enjoin. a lawsuit, it fits the definition of the right to petition. If you're looking for an injunction of a right under this act, you can find it with association. They are attempting to stop communications by my clients with the members. I don't believe that the court needs to analyze whether or not this is a prior restraint on speech, because the complained of conduct is simply interfering with the right to association, communications with the members about all sorts of things, including pilot training.
Well, okay, we'll get to that in a minute, maybe. But I mean, you're talking about the injunction itself is not a claim; it's a remedy, right? You can't. It's not a cause. Injunction is not a cause of action. It's a remedy.
It is a claim. Going back to the definition, it is a lawsuit requesting relief. And that fits the definition of a claim in the act.
And the lawsuit here, the claim here is a request for a judicial declaration of who the duly elected officers of the Northeast Tribe are or is, right?
Correct.
Okay.
But the complaint of conduct is filing a lawsuit, and the complaint of conduct is representing to everyone that they're officers. That's protected speech. That's protected association right, and that's protected petition right. If you read the cases that we cite, this is exactly how courts interpret it. Hey, if you complain about it, filing an abstract of title and ask for relief based upon it, then the act applies to this, and it is subject to a motion to strike.
It's difficult for me to see when this act wouldn't apply.
That's correct, Your Honor. I agree.
And so then how do we comport that then with our pleading standards, for example?
Well, Your Honor, if a claim does not implicate a right to association, and in this case is supposed to be about a corporate governance dispute, but there's all this stuff in there that has nothing to do with the corporate governance dispute. And that
do you mean when you say stuff, do you mean facts?
No, yes, the facts pled are protected privileged communications under the act. This lawsuit, this governance lawsuit, could have been filed not mentioning my clients at all. They could have just pled, here's what I did to hold a valid election. And instead, they are complaining of the protected conduct of filing a lawsuit. They're complaining of the protected conduct of communications within this association. And we haven't got to the right of free speech yet, but it's our contention also that they're complaining about conduct that is protected, privileged free speech as defined by the statute.
Are those the claims though, or are they facts asserted to support the claims?
They are both. The counts reincorporate every allegation in the suit. You'll see in the initial paragraph.
That's pretty standard. Okay.
It is, and they also mention specifically, count 3 mentions specifically filing the Michigan lawsuit and making a filing with the Kansas Secretary of State. So it's subject to the act. In count 2, they are attempting to stop direct or indirect communication, sending emails to the membership. They're trying to provide a prior restraint of holding themselves out to be members or officers of the tribe. This is precisely the kind of conduct that fits the definitions in the act.
Well, it's not a prior restraint. That would be the permanent injunctive relief if it's found that your clients were not the duly elected officers.
That's correct.
Then an injunction would be appropriate to preclude them from representing that they are the duly elected officers, wouldn't it?
The claim can be, it doesn't matter, according to the definitions of the statute, it doesn't matter whether it's alleged to be authorized or unauthorized. If the conduct complained of If the relief requested arises out of conduct that is privileged by the act applies. And this is especially
Well, I
in,
thought you just agreed that it doesn't. I mean, the injunction would prohibit them after they found to be not the elected officers from representing themselves as being the elected officer. That's not there's no first of all, there's no prior restraint in that. Secondly, I don't see how it impedes what would be a protected right unless they have, you're saying they have a protected right to falsely represent that they're officers of the Northeast tribe after the court has declared they aren't.
no, Your Honor, I am not asserting that. What I am asserting is the conduct complained of fits the definition of privileged communication regarding the defined rights. That's all I'm saying. Therefore, it is slappable under the act. You can file a motion to dismiss or a motion to strike based upon the definitions in the act. It doesn't matter if the allegation is authorized or unauthorized. What matters is the complained of conduct is a privileged communication. Moving on to the right to free speech, I did want to note that the definition of the right to free speech includes something that the other definitions don't, and that is that the speech must be made about an issue of public interest. And
excuse me, Mr. Wilson.
yes,
you're getting into some of your rebuttal time. I want to maintain that for you because we asked you questions, okay? As far as a free speech, is it going to take you very long to address that, or do you want to save it for your rebuttal?
Well, I will say this, Your Honor, and then I will reserve the rest of my time. Both parties agree that the dispute they were having is about speech. You know, they both agree it's about pilot training. Our guys say they want more pilot training. Their response was this dispute is about advertising, and advertising is speech. So every paragraph in there that complains of the speech that they make is subject to this act. And with that, I will reserve the balance of my time for rebuttal.
Thank you. Mr. Spahn, allow Mr. Wilson to go over a little bit, and I'm not going to just constrain you to the 20 minutes if you need extra time.
All right.
Are you ready for your argument?
I am. May it please the court, counsel. This case is purely about who are the officers of this private club, the Northeast Comanche tribe. It is a private club. It's not public. We believe elections have been held that elected have Shiloh as the tribe chief and others as other officers of the Northeast Comanche tribe.
Before we get too deep into that, let me jump to what I talked with Mr. Wilson about at the start. Do you agree that we can reach the second step of the anti-SLAPP analysis if we agree with him or assume that the first step has been met?
I think it's up to your honor to go to step 2, but we don't think they've met step 1.
Well, that's not, I mean, the premise of my question is that we either assume they have or we find they have. Is it your position that we can then move to step 2 and decide that?
I think that would be appropriate for this court. You can certainly remand it and have the district judge make those findings, which he did not reach because he found they didn't reach step 1. But
right, but I mean, the issue of step 2 was presented to the district court and there was argument made, and obviously the materials are in the record that deal with that, correct?
that there is, your honor.
Okay, and the standard we're supposed to apply in step 2 is whether there's essentially substantial evidence of a prima facie case.
Correct.
And that's a legal question.
Correct. And we offered evidence below and in our appellate brief showing that elections were held, that bylaws do exist, and that Mr. Shiloh was elected as the tribe chief, as were other officers, and that it is improper for the defendants to continue to claim they are the duly elected board, which is part of the problem that we've had and that generated this lawsuit. Did I answer your Honor's question?
Well, I think so. But
All right.
my next question is then, assuming we look at step 2, what do you say to Mr. Wilson, who says your amended petition on its face is insufficient to establish a prima facie case for a resolution of a dispute over who the officers are?
Well, we did allege that there are bylaws that exist that call for elections, and that the defendants did not hold elections. And in fact, Ms. Stumpf had been expelled from the membership of ICS. 2 of the other officers resigned. They were not members of ICS.
Well, I mean, I think what he was pointing to, at least in the argument, was a requirement under the Kansas statutes that the election that Mr. Shiloh was chosen in was conducted under the auspices of the board of the Northeast Tribe, and it wasn't. I mean, what's your response to that?
My response is our election was held under the bylaws per the terms of the bylaws. And therefore, we did make out a prima facie case that we followed the bylaws and held the elections. And so therefore, we were elected. They claimed to be holdovers when in fact, they weren't even members anymore because of either resigning or being expelled. So, and our further argument is that if there's any dispute over our election under the bylaws, the district court can order an election under the Kansas Corporation Code. And that's part of the relief that we asked for, is that, you know, if our election wasn't properly held, which we believe it was, we know that they weren't conducting elections. They canceled elections and tried to stop elections from occurring. The court, as part of the Corporation Code, can say, listen, we're going to hold an election and decide this once and for all. But the defendants don't want to see that happen. They don't want the court to order an election to occur. And so that's our argument, is that we believe we were properly elected following the bylaws that do exist. There's a dispute, and we think the district court can decide who won the election, or if there wasn't a proper election, can order the election. And that's the remedy that the legislature provided the Northeast Comanche tribe. And what I point out on the SLAPP statute is there's really 2 purposes of the SLAPP statute. And all Mr. Wilson wants to talk about is the first step, which is protected speech or the protection of the right to petition or association. And he doesn't mention the second part, which is to protect the rights of parties to bring a lawsuit to have a claim adjudicated. What they are saying is Northeast Comanche tribe does not have a right to bring this petition to seek relief, that Kansas law provides it to have bylaws, a determination whether bylaws did exist and whether Mr. Shiloh was properly elected, or that an election should be held. And they seek to strike that right, and under the guise that we somehow have implicated their rights.
Mr. Spahn, I'm sorry to interrupt.
Certainly.
I believe one of Mr. Wilson's arguments is that you haven't sufficiently pled or correctly pled your claim regarding the election, according to Kansas statutes. Do you believe that you have a higher pleading standard in this case, or that you have sufficiently pled that action?
I believe we sufficiently pled it because we pled what the bylaws provide, which the defendants claimed there weren't bylaws, but we pointed out, here's what the bylaws provide, and we held the election. ICS, as we are part of the ICS organization, said that they would tally the ballots or provide their voting platform so that the members could vote, which they have the right to do. And that's how the election was conducted. We think we pled that, and that we properly followed the bylaws by holding an election, notifying members that they could vote. Members voted. And what is interesting is one of the defendants ran in that election, Your Honor, Defendant Morse. He participated in that election that he now claims is bogus, and he ran against Mr. Shiloh. And Mr. Shiloh won more votes. And now the defendants say, well, okay, you didn't run the right election. So, they had filed several motions for failure to state a claim in this case. And both times those motions were denied. The judge looked at this and said, no, you stated a claim.
Well, that's a different standard though, isn't it?
Well, it is, Judge.
I mean, it's a different standard. It's a more relaxed standard than the step 2 standard here.
Well, the step 2, we have to show substantial competent evidence. You are correct on the failure to state a claim. He looked at it and said, no, I think you've stated a claim. He did ask that we amend the complaint to add Mr. Shiloh. So we did that. But this argument that our amended petition was somehow deficient, that's just wrong. It was properly pled. In fact, there were numerous facts alleged about the bylaws and that the defendants hadn't been following it. So
let me shift back to the stage 1 determination that the district court did make. I mean, obviously, in your appellate brief, you're defending that. Admittedly, the definitions in the anti-SLAPP statute are intentionally quite broad as to what is covered and protected. How is it that this suit doesn't in some way implicate the speech rights as they're defined in the statute of the defendants?
Well, first of all, you have to look at the language of the statute, and the right of speech says it has to deal with an issue of public concern or public interest. And in this case, this is a private club. There is no public interest or concern about who the officers are of this private club. So they fail to meet the step 1 analysis by showing that the right to speech has been implicated because there's no public concern or public interest. What they try to do is then come in with affidavits saying, well, what your lawsuit is really about is pilot safety training, and who's in favor of more training or less training. Well, that's improper.
Why? I mean, why is that not a speech issue affecting health and safety as they allege?
What we are saying is what we pled, we did not plead any allegations about the defendants think that more pilot training is necessary and we think less. That's not in the petition. What's in the petition is that the defendants have disparaged the current tribe council by stating that they lack authority. They are not the true officers and that the defendants are the true officers. Well, that's not an issue of public concern or public interest. If you read that out of the statute, Your Honor, then everything is covered by the SLAPP statute. And as Mr. Wilson said, yes, every lawsuit is subject to a SLAPP motion. And that's what he intends. That's his argument, is that if you say anything about what somebody said, SLAPP is invoked. And that's not the case. It's very clear that the right to speech has to deal with a public interest or public concern. And the only way they get to health or safety or the government is they bring in these affidavits saying, well, the FAA regulates pilot training or pilot safety, and we think there should be more training, and another group thinks there should be less training. But that's bringing in extraneous, I don't even want to call it evidence, because that's the defendant's subjective belief on why the lawsuit was filed. And even Mr. Wilson conceded Shiloh's subjective motivation for filing this lawsuit is irrelevant. That's what he.
What about the claim? I mean, we've referred to it as count 3. I mean, I think that's right. That essentially seeks to recoup the legal expenses for the Michigan lawsuit from the defendants. That I don't know how much money's involved in that, but that seems like an intimidating sort of claim that at least is in the ballpark of the kind of stuff that the anti-SLAPP statutes are intended to head off.
I tell you why it isn't. First of all, as Your Honor pointed out, in the Michigan case, the defendants, Stumpf, Morse, Ward, and Dickinson, were not parties, okay? They were not parties. Mrs. Stumpf did cause the corporation, Northeast Comanche Tribe, to file the lawsuit, trying to stop the election and trying to declare that there weren't any bylaws, but she didn't use her own money. She used the corporation's money. There is no right to use somebody else's money to file a lawsuit. That does not implicate the right to petition on a case that they are not parties to. What it's doing is using corporate funds that, frankly, they had no authority to do to pursue this claim of theirs that elections shouldn't be held. So that's my first argument, is that they weren't even parties and they're using somebody else's money. And if you say that the right to petition includes using somebody else's money to file a lawsuit, you are reading that's opening up a huge can of worms that I don't think this court wants to broaden the SLAPP statute to say, yes, that's protected conduct. You can use somebody else's money. The other things is that they cite in the petition where we allege defendant Dickinson had testified under oath that there were some bylaws and that he found them and gave them to his cohorts. And he believed that bylaws existed on the website. We cited that simply to show, yeah, there actually were bylaws. But what's interesting is defendant Dickinson did not file this motion to strike, Your Honor, at the district court. Defendant Stumpf did, but we don't cite anything in our petition that she communicated in the Michigan suit. We do cite that Dickinson swore under oath that he found bylaws. Now,
did he find bylaws or did he find evidence of bylaws?
He found the bylaws. They were in a box. What he did is he found them, he gave them to counsel, he gave them to his colleagues, and then they sat on them.
Well, no, I understand. I mean, I read the Michigan Court of Appeals decision, and I'd have to go back and look at it. And I don't think it's actually that pertinent here. I thought he found stuff that indicated that there were bylaws and references to the adoption of bylaws, not an actual signed set of bylaws. But no, I may be wrong.
No, he found bylaws. He found.
All right, it doesn't matter. Go on.
Yeah, he found the bylaws.
Okay.
And he found evidence that they had adopted bylaws. Now, on this association argument, which is, I don't quite understand, but the defendant seems to say we are trying to prevent them from communicating with any member of the Northeast Comanche tribe. And that's not what the petition alleges. What we don't want them doing is using the Northeast Comanche tribe's directory, their membership directory that they own and have, that's the resource that they have put together, and to use those email or listservs to send out communications as the officers of the Northeast Comanche tribe, which is what they've been doing. I would point out that in the Michigan case, Your Honor, they agreed not to do that. There was an order entered that they agreed to that they would not do that. They wouldn't use the Northeast Comanche's directory to send out such communications. Well, they've now ignored that Michigan decision and that Michigan order, and they continue to do it. And
let me ask you a question, and I'm trying to see how to phrase this exactly. There's a dispute, at least, about the historical progression of the bylaws as to when they were adopted and when they were revised. I mean, there's the 92 references and then I think 97 or 98. Is there an agreement that there is a current set of bylaws that exist for the Northeast tribe? I mean, is there something that if I went and looked right now, everybody would agree are the current bylaws?
No, there is not, because the bylaws that existed in 92 and were updated in 98, the defendants say were never adopted. And then after the defendants were either resigning from the board or expelled for misconduct, I believe some bylaws were adopted in the last couple of years, but the defendants are not going to agree that that my client adopted those bylaws. And on the step 2 analysis, the articles of incorporation say that the conditions of membership in the Northeast Comanche tribe are to be set out in the bylaws. And they were. That what do you have to do to be a member? If the defendant's argument succeeds that there were never any bylaws at all, then anybody could be a member of the Northeast Comanche tribe. You don't have to join ICS. You don't have to fulfill any condition. You or I could be a member of the Northeast Comanche tribe by just saying, I'm a member, if the defendant's argument that there are no bylaws prevails. And that's simply wrong.
Mr. Spahn, the way you've brought a declaratory judgment action, essentially seeking to establish who the duly elected officers of the Northeast tribe are. Is that a fair statement?
That's exactly right.
Okay. So if this case goes back and it proceeds on that, the district court could find, in fact, that the defendants are the duly elected officers. I'm not asking you to agree with that, but that could be a result here, depending on how the evidence comes in.
Absolutely. That could happen, and we're prepared for that. We think we will prevail.
Well, I understand that. And I'm not asking you, to project the outcome, but essentially, and I mean, the judge theoretically, I guess, could get to the end of the line and say neither slate was properly elected. Is that a possibility? Okay.
That's correct. And under the statute, he can then order an election. And that's
under using what guidelines at that point? I mean, if what's in the bylaws, or if there's no bylaws, what happens? I don't know corporate law, but
it's the Kansas Corporation Code that sets out.
Well, I understand that. I don't know that. So what would happen in that situation? If you get to the end of the line and he says none of them are duly elected and there weren't any bylaws.
He would oversee the election. Typically the elections have like a 2-week voting period, because these people are spread out all
over the
country. And so he would order, here is how the election will occur.
He has the authority to do that.
Yes, he absolutely does have the authority to order an election. And then, if that occurred, then this confusion and anarchy that the defendants have created for the last 3 years would be over. And we could move on. But instead, here we are 2 years after we filed our lawsuit, and it's pretty clear the defendants don't want to hold elections. And they want to continue to hold themselves out as the duly elected officers. And this creates confusion for this private club. It's not a public interest, but it's a private club. And, there's limited resources. The longer this thing is drug out by the defendants with all of their motions, the greater likelihood this club just goes out of existence. It just, when you have two competing groups saying I'm president and another says I'm president, you got to get it resolved. Because we can't continue with this limbo that the defendants have put us in. And that's the remedies, that's the relief that we sought. Because it was a DJ action, we said, there's a real dispute. They claim they're the tribe council. We claim we are. We claim there are bylaws. They say there are not. We got to get this sorted out because if we can't file a petition to get it sorted out, then what is our remedy? We can't just resort to, brute force, I'm in charge or I've got the bank account. We've got to go to court. And that's what the legislature said. Yes, the district judge has the power to make these determinations. And if he concludes no valid election was held, he can order an election. And so that's the relief that we asked for. The monetary damages relief, we just said, listen, they spent some money in Michigan that belonged to the corporation. And you know, it belonged to the corporation, and so therefore it should be refunded. The court may say, no, they don't have to refund it, but the fact is they did file it. We've also sought some minor monetary damages because they keep filing things with the Secretary of State saying that, annual reports, et cetera, saying that they're the board. And we have to undo that. And so you have these conflicting filings, and that costs money anytime you try to file something with the Secretary of State. So that was very de minimis, but we said, we're going to ask for that as part of our damages, because we shouldn't have to do that after CJ Stumpf was expelled 3 years ago. And now she's continuing to say she's the head of the organization. So anyway, I think I've kind of captured everything I was going to say, and I know I've gone over my time limit. I'd be happy to answer other questions if anybody has any questions.
Any other questions from the judges? Well, thank you very much, Mr. Spahn. Mr. Wilson, you have your rebuttal time left.
Thank you.
Mr. Wilson, before you get rolling, let me ask you a question. Why don't your clients want a judicial declaration that they are the duly elected officers of the Northeast tribe?
They do. And the reason—
isn't that what this lawsuit is going to get to eventually?
If this lawsuit were simply about a governance dispute, it didn't even have to mention my clients at all. They would just need to serve it on my clients, and we would respond with a motion and a memo of law about why my clients are the duly elected officers. That's what this should have been. Instead, plaintiffs pled into the act by claiming disparagement regarding the representations about their association with the tribe. They admit that they're seeking relief for government filings, and that fits the definition of right to petition under the act. And one thing I would like—
okay, but the ultimate relief here will be a judicial determination of who the duly elected officers are.
That's
and
correct.
It might be Shiloh and his bunch, and it might be Stumpf and her bunch, and it might be neither one, I suppose. And I don't understand why are your clients fighting and screaming to prevent that from happening?
No, they are not. They're simply pointing out that the complaint of conduct fits the definitions under the act.
Well, but they didn't have to file the motion to strike.
They didn't have to, but they have, because it's their right. It says the legislature has amended the civil code to permit precisely this type of filing. My clients believe this lawsuit is completely without merit, and this is a great way to shift the burden to the other side to show that they have pled by substantial competent evidence that they actually have a claim here. That's what's going on with this motion. It's getting to the heart of things and getting rid of those extraneous things that don't belong in a suit like this and should have never been pled in the first place. But, Your Honor, I did want to address the sort of the floodgates argument of opposing counsel. The definition of claim is extremely broad, but this act only applies to the very narrow set of protected rights as defined in the statute: the exercise of the right to association, free speech, and petition. That's it. If they wouldn't have mentioned the Michigan lawsuit and sought damages for it, then the act would not have applied. If they would not have complained of the communications within the association, this act would not have applied. But
that's not really true. You're saying it applies because of the dispute over pilot safety and who could place advertisements in the Northeast. that would exist regardless of those allegations, and right?
Your Honor, that is true, but that is a public issue like this is only relevant to the free speech analysis, not the analysis of association and not the analysis of petition. The cases are very clear. If you file a lawsuit, you're complaining of the conduct of filing a lawsuit, then the burden shifts and you need to show that you have properly pled. And if you invoke the right of association.
Well, I mean, you were saying, well, there's no floodgates here because if they had pled just the corporate governance issue, you wouldn't have a motion to strike. But your position is you could bring a motion to strike based on this apparent dispute over pilot safety and advertising related to that, regardless of whether it's in the petition or not.
That's correct, Your Honor, because the statute says the district court must, shall consider the affidavits.
Well, doesn't that
in this case, they admit that this is about advertising and it's about speech as well.
Well, it seems to me then that's not an argument against the floodgates. I mean, it's an argument for cranking open the gates and letting the water flow.
Your Honor, if the free speech, the allegations in the suit do not fit the definition of free speech, including its public issue element, then the act doesn't apply. But in this case, it does. So we are identifying in their pleading the conduct that fits those three definitions of association, petition, and free speech. And we are saying, as the all cases, including the cases cited by the opposition, the act applies broadly to any time this protected, privileged communication is implicated in the lawsuit, and anytime it arises out of or relates to, very low bar, relates to the protected conduct. Now, the burden should shift, and it's not an extraordinary burden. They just need to show by substantial competent evidence that they have a claim. But the definitions don't require that a judge evaluate whether there was an actionable violation of the defendant's exercise, but only that the definitions are satisfied. And if they are, the burden shifts. There's no need to find bad faith, bad motivation, suppression, malintent, or intent of any sort. If it's in the petition and it fits the definition, it satisfies step one and the burden shifts. And you certainly don't need to find the claims themselves are meritless. That's a step two argument, but only that they relate to the privileged communications, which would then satisfy step one and the burden shifts. The court doesn't need to speculate whether the Michigan lawsuit complained of or the other communications will, in the end, be authorized or unauthorized. If a plaintiff complains of privileged communication, the act applies, step one is satisfied, and the burden shifts. The act provides objective and not subjective criteria to apply to definitions that reduce the rights to statutorily defined conduct. And this is discussed in the Exxon case. And I have another California case that was decided after briefing that I could discuss if the court permits. And really all this should be is a corporate governance dispute, but they have made this about so much more. They have complained of conduct that is a protected communication under the statute. The act applies, and if the act applies, then the court must go to step two and make that analysis. Those points in step two, you asked me to make right up front, Your Honor. I would like to take any questions that any of you may have.
Are there any other questions? Well, thank you, Mr. Wilson.
Thank you, Your Honor.
We appreciate, these are very interesting issues, and we appreciate your arguments from both sides. We'll take this case under advisement, and we will try to get you a written opinion as soon as possible. Thank you for your arguments, and